Smith-Johnson on behalf of Mr. Mark Levin. And Judge, if I'm not mistaken, I believe Madam Clerk apprised you to Mr. Levin's current status. He is in the medical ward right now.
Right.
All right. Judge, I'll be brief, and I thank you for allowing me to go first. I believe myself and ASA Jones have made light of the court's work this morning. Subject to court's approval, the state has agreed on the one charge, the possession of cocaine with a firearm. Subject to Your Honor's approval, the state has stipulated to a $5,000 bond on that count. And I believe, Judge, if I'm not mistaken, Mr. Levin should have the benefit of bonds on the remaining counts. I have no objection nor argument to those bond amounts. I think they're reasonable as set. So if Your Honor is inclined to agree with the stipulation on the $5,000 bond for that no bond count, I think that takes care of Mr. Levin's first appearance, Judge.
All right, State?
Yes, Your Honor, Brenda Jones for the state. Yes, Your Honor, that's correct. I see no reason why it would even be filed on as possession of a cocaine with a weapon. It wasn't particularly used in the commission of the offense. It just happened to be found in the car. And per the arrest affidavit, the defendant also immediately tells the officer upon request that there are indeed 2 weapons inside the vehicle.
Okay, so probable cause then, I'll go with the state stipulation on the $5,000 bond. Stay the other bonds.
Is counsel waiving?
Yeah, I'm assuming you're waiving your client's appearance, obviously?
Yes, Judge, because of his aforesaid medical afflictions. Yes, sir.
Okay. Take care of it? All right.
Judge, that's all I had. May I be excused?
Yes.
Good to see you again, Judge.
Okay. First count, everything else is stayed. Rivera with Mr. Quintana.
Good morning, Judge.
Good morning.
How are you this morning?
Okay, how are you?
Doing all right.
I see we're waiting for probable cause on the trafficking, it looks like.
Yes, sir.
All right, State?
Yes, Your Honor, the state did reach out to, hold on one second. The officer, Deputy Donnie Registe, he indicated that he did file an amended arrest affidavit for this defendant indicating the weight. However, I do not have access to that. I have tried to look at the clerk system to see if there was anything that has been filed that I can view myself. So at this point, the state would just be asking for a final 24-hour reset, as there's an indication that the officer has sent the amended affidavit indicating the weight to find PC for count 1.
Okay, defense, anything else?
Judge, I mean, look, we would just object on the grounds that if you just look at the original affidavit, it doesn't even say anything about them weighing it. And of note, there's a co-defendant. And so the affidavit facts basically say that what they find is something falls off of his lap. The rest of the stuff is found in a center console. They do arrest both individuals. There's no indication how they've apportioned the weight between the individuals. There's no indication that how much they've weighed, if they've weighed anything. But you know, we already had a 24-hour set. I mean, was there any indication, State, did they say anything, or did they just say we sent a report and it has the weight on it?
They just said they sent an amended report that included the weight. I don't believe that they said it only included an amended report, only including the weight.
No, I just mean, was it over the threshold 4 grams? Did they say, okay, it's 10 grams or it's 4 grams?
I was given no other information other than that they submitted one.
Well, State, if, let's say there is sufficient weight, are you going to agree to a different bond amount, or?
If there was sufficient weight, the state would just leave it in Your Honor's discretion as to what the appropriate bond is for the trafficking charge. I believe there is a bond for counts 2 and 3 as well that were already entered by Judge Bain.
And what are his contacts here and his history, do we know?
Judge, I can tell you what his contacts are. He's married, his wife lives here. He's lived here for 3.5 years here, specifically in Central Florida, 1.5 years in Tampa. He has a minor child, a 10-year-old who's enrolled in school. He has 2 other adult children that live here. He has a sister who's lived here for 13 years, and he has a cousin in Tampa who's also lived here for many years, for 15 years. and a brother in Miami, Florida. He doesn't have home or assets anywhere outside of Central Florida. We'd be willing to pay a reasonable bond. But, at this point, we're thinking we've already had 24 hours. There's no indicia that it's even a trafficking amount. And even if it were 4 grams, how do they apportion that between the two? The other co-defendant was just charged with possession. Instead of waiting, I would say, if you issued one bond on this count and then the other 2 counts, like maybe a $20,000 bond on this one as the most serious theoretically, and then $150 bonds on the other 2, that would be much more than sufficient. I am retained. I have filed my notice of appearance. I'll make sure he shows up.
And for the history, Your Honor, on the information sheet, it says that there's multiple out-of-state convictions, including an outstanding warrant out of Pennsylvania.
Outstanding warrant?
Yes.
Are they going to extradite him or not, or?
It says that they are not going to, no extradition, in-state pickup only.
I love the way the states do that now. They don't want him back, so they just don't extradite him. That's a scam going on, isn't it? Man, oh, man. Okay, so 20,000?
Judge, one $20,000 bond and counts 2 and 3, 150 or 100, however
Right.
you guys do them. I think that would be more than sufficient, guarantee
Okay.
for everybody
State?
involved.
Any objection?
No objection from the state.
No objection, okay, so 20,000, 150, and 100.
Thank you for your courtesy, both of you, Ms. Jones and Judge.
Yes, there was a 7,500 here, we're going to modify that. On what? Yes.
Entiendo, vas a salir, te van a dar una fianza, lo que tengo que resolver es el último casito que está en Osceola, pero eso el lunes lo debo de resolver al más tardar. Okay. Sí, vas a salir, no sé si vas a salir hoy mismo, voy a verificar.
Yes, we're going to stay the random urinalysis, no contact with any known drug dealers, do not possess, consume any, says alcohol, illegal drugs, controlled substances without a prescription. I don't think we need to do the alcohol, we'll just say the illegal drugs. Yeah, take the alcohol off. Okay,
Yes, sir.
all right,
Judge, thanks again for your courtesy, and Ms. Jones, thank you as well.
all right.
Whoa, ¿está bien?
What's Mr. Barker here on?
Good morning, Your Honor. I have Ramondo Williams.
Williams? Okay. An arrest warrant here for trafficking, MDMA, cocaine, battery, Leo, carrying concealed firearm by convicted felon, fleeing and attempting to elude. Now, there's no bond on the fleeing and attempting to elude. Of course, he's entitled to a bond on that, as far as I'm aware of, and then the trafficking with a firearm, is he entitled to a bond on that, or is that a punishable by life?
Your Honor, the weapon makes it a non-bondable offense.
So it's a PBL with a weapon?
Yes, Your Honor.
Okay. There's a warrant, so there's probable cause. Count 1 has a $50,000 bond. The trafficking is none at this point. Batteries, $1,500, $4,000 on the weapon by a felon. And on the fleeing and attempting to elude. I will set a $2,500 bond. Anything else?
Nothing from the state? State would request no weapons or firearms if he is
Or
able.
he's not to well, he's on no bond on the 2, so. Yeah, we'll put on all the counts. He's not to possess any firearms or weapons. Okay. All right, I'll take care of it.
May I speak on my client's behalf as far as bond is concerned, Your Honor, on the counts that have no bond?
Well, it's a life felony, correct?
Correct. There's a standard bond. There's a bond schedule has this at 500,000, but I have some argument to make why it should be lower.
Okay, go ahead.
Mr. Williams hired me in August when he found out there was a warrant. I looked on the FDLE website. It confirmed there was a warrant for trafficking. I talked to the state. Mr. Williams was very adamant he wanted to turn himself in. I told him it looked like there was a no bond on a trafficking. I didn't know at the time it was with a weapon and thought that bond should be set. I contacted the state attorney assigned back in August. We've been going back and forth. When I originally talked to her, she said, yeah, it looks like he should have a bond on this. I don't know why, but she's about to go on vacation. Long story short, the state attorney and I have gone back and forth. He's called in constantly wanting to turn himself in and get this started. I believe that indicates he's not a flight risk. The bond schedule that I looked at yesterday has, this is, I think it's 500,000. Trafficking in cocaine over 400 is standard 250 with a weapon, 500,000. The state has not made a filing decision yet on the case, and so I'm asking the court. He's got a family, he's been in Central Florida whole life, that the court set bond on the trafficking that doesn't have a bond at 100,000, and the fleeing, I didn't hear what the court set bond at.
2,500.
2,500.
Anything from the state?
Nothing from the state. State's not changing the argument. Notably, there is criminal history, 4 felonies, 8 misdemeanors, and
He has what again?
4 prior felonies, 8 prior misdemeanors. The last conviction, it was in 2017, which also involved the weapon, Your Honor.
Where was the weapon?
In this case, Your Honor?
Yes.
Hold on, I'd have to check. All I have is
Let me
on
see
the arrest
if
report
it's
is that
here.
there was a warrant.
So I keep missing it.
It looks like a pistol on the original affidavit for arrest warrant. on the driver's side floorboard.
A what?
A pistol on the driver's side floorboard, according to the original arrest affidavit that was filed.
I don't know what you're saying.
A pistol? You asked what the weapon was?
Yes,
A pistol, a gun.
a pistol. Oh, God, you're saying a pencil.
Oh, I'm sorry. I apologize.
I go, a pencil. There's a pistol. And is it loaded and,
It does not have information of that. It says that on the driver's side floorboard, there was a pistol wrapped in black cloth with bags of marijuana.
all right, and who was the driver?
It looks like,
Williams. Yeah.
yes.
Was-
Sorry, I had to scroll up.
It's all right.
Your Honor, of course, the affidavit for arrest warrant is not public, so I haven't been able to read it. I don't know if that indicates that Mr. Williams was in the car when the police searched it and found the weapon.
He fled
They
the
ran.
car and the police.
All right, I'm going to set bond at 500,000. Okay, not to possess any weapons, any illegal drugs.
Would the court consider setting the other bonds at 100 since this one is so high?
Not with everything there.
Thank you, Your Honor.
Same conditions. So, Mr. Voorhees here, this is a violation of probation.
Your Honor, for the record, Dominique Cunningham from the Office of the Public Defender.
This is currently set at no bond. All right, anything from either side on this one?
Verna Jones for the state, nothing from the state.
Nothing from the defense, Your Honor.
Okay. He's appointed. Ron Burks,
Yes.
PD's appointed. Arrest warrant was issued. Delivery of controlled substance, sale and delivery of methamphetamines, possession of meth. Bonds of 5,000, 2,500, 150, a total of 7,650. PD's appointed.
Sir, is that why I'm here today?
Is that what?
Is that why I'm here today?
That's why you're here today.
Okay, listen. I was formally arrested on trespassing charges. I'm just saying because I was formally arrested on trespassing charges, and I've never going through the intake part. I was never found to have any drugs or anything on me, and I did not in any way have any drugs or drug issue when I came in here. I don't know why they came with those charges, because there was no warrants for my arrest at the time, but nothing but trespassing of property of Family Dollar, which is in Eatonville. Did not know nothing about nothing. I've been getting trespassed from the same place for the last couple of days. I've never in nothing have no sale or delivery.
All right, well, your attorney will have to look into that, sir. All I know, there's a warrant there.
Okay, I'm just wondering where these charges came from because I was sitting on my bunk.
Your attorney will get all that information, go over everything with you. Okay, just give him some time.
Okay, so what's up with the trespassing charges? Because I never went to court on those charges.
I don't know, sir. I told you all I have. Again, your attorney will get to you and discuss things and figure it out.
How long would it take for the attorney to get in touch with me?
You should be assigned a public defender on Monday or Tuesday, and they'll get in touch with you.
Okay.
Okay. We have Derek Kuntz. Kuntz, you're here on a failure to appear. The bond's $250. Division 80, public defenders appointed.
I got a question.
Olvin Kalik. These are Spanish?
Yeah.
So we need an interpreter?
Yes. The next part, please.
Good afternoon, this is Dalia Romero, Spanish interpreter on the line already sworn in.
Okay, we're here at the Orange County Jail, and we're calling this is 2021 CF 138498O. Olvin Kalik, Calix. We're appointing the public defender. It's Division 12. And he's out on bond on a suspended license charge. The new charge is possession of cocaine. That bond will be stated 1,000. And now the suspended license case, is he out on bond on that, or is that just an open case?
No, Your Honor, that was an entry error.
Okay. So we'll take no action on that. Okay, public defender appointed.
Okay.
All right, the next one is 21 CT 7045. What's that? I'm trying to figure out how to pronounce it. Oh, okay. Bonded. So who do we have next? Over there. Fuentes, okay? Okay, we'll appoint the public defender. There's a, is that on surety bond, on driving while license suspended with knowledge? And there's a failure to appear. Division 85, there's a bond of $2,000. case he's out on bond, going to revoke the bond at $2,000 and put the bond at $4,000. So we'll revoke and discharge that original bond back to the bondsman and add the new bond of $4,000. He's appointed.
Está bien. Gracias. Gracias.
Thank you.
Alejandro? All right, this is a driving under the influence charge. Public defender is appointed. Division 81 says. And the charge of driving without a valid license. The bonds were set at $500 on each count.
I'm sorry, Your Honor, how much is the bond for the interpreter? Yeah.
500 on the DUI and 500 on the no valid license, total of 1,000.
Okay.
Next one is Sierra. Appoint the public defender. These are out-of-county warrants. And looks like their failures to appear on domestic
Este es un caso.
batteries. And there's no bond, and we'll appoint the public defender while you're here in this county. It's like they're out of Monroe County. So they should come to pick you up here in the next, hopefully, week or so. I believe that's it for the interpreter cases.
Thank you, Your Honor.
We have one
Good
more?
afternoon.
Which one? What's the name? I couldn't understand the name.
Yeah, Augusto.
Augusto.
The source pulled this one out, but probably was me. Probably didn't.
One of them. I guess you get a demerit for that. Huh?
No, it's weird. No, it doesn't like.
This. What is the full name?
José Agosto.
José Agosto.
Okay, so now the county warrant with no bond out of Lake County. We'll appoint the public defender while you're here in this county. They should be over to pick you up hopefully within the next week or so. The next one is Gaines.
Thank you, Your Honor. May the interpreter be excused?
Yes, ma'am, thank you.
Have a great weekend. Thank you.
Too much fun, eh? Okay, Mr. Gaines is here. He has a warrant issued for battery with a prior battery, domestic, violation of pretrial release on a domestic case, aggravated assault, hindering communication to law enforcement, false imprisonment is on the new warrant.
Your Honor,
Hold on, sir. Public defender is going to be appointed. And then it says he's out on bond.
Yes, Your Honor, he's out on bond in case number 2021 CF 12372.
And when was he released on that bond?
Let me check.
This says 9/24. Okay, and this new one happened 10/11, so.
Yes, Your Honor.
All right, so I'm going to revoke the bond on the 2021 CF 12372AO. That'll go to no bond. And then the new charges, I'm going to set bond at $5,000 on each count, so a total of $25,000, no contact with the victim.
Your Honor,
Yes?
if he were to gain a bond on the other cases and be released, we'd ask for a one-time return with law enforcement.
Yes, may return one time only with law enforcement to pick up personal items.
Okay, Your Honor, can I say something, please?
Separate residence, no return to the scene of the offense. Yeah.
This isn't the job.
Joseph Grafal.
Yes.
All right, aggravated stalking after an injunction, violation of domestic injunction, violation of domestic injunction and contact, and the other one was injunction coming within 500 feet of the petitioner. That's per a warrant, so probable cause was found. The order to have no contact with the victim, no return within 500 feet of the victim or her home or place of employment.
So you're gonna get one.
Because I thought all this was resolved.
I understand.
All right, on the aggravated stalking after an injunction state, you have any history?
Your Honor, the only history I see that there was a prior arrest of a battery with a domestic violence with the same victim, but I see no other criminal history other than there is an active final injunction with this victim.
All right. So on the stalking count one, there'll be a $7,500 bond.
That's all I needed.
And count two will have a $500 bond, and count three will have a $500 bond. Anthony Heath. Heath is Division 14, aggravated assault, domestic violence. We'll order no contact with the victim. Separate residence. Anything from the state?
One moment, Your Honor, I'm just checking something. Just due to the nature of the charge, the state would just ask that there be no weapons or firearms in addition to the other conditions.
Your Honor,
Oh, okay. Hearing impaired. All right. So can you hear now? Can you hear me?
Yes, sir.
Okay. So you have a charge of aggravated assault, it says domestic. There's probable cause. We're going to order no contact with the victim. Separate residence. State anything on a bond amount?
No, Your Honor. As for the history, it looks like there is 14 prior misdemeanors, 1 prior failure to appear from November of 2018, and it looks like he is designated as a violent felony offender of special concern, which wouldn't affect this case unless it were a VOP, but nonetheless, it's a designation.
Bond at $2,500.
Your Honor, we'd ask for a one-time return with law enforcement.
Yes, one time with law enforcement to pick up personal items. All right. We need the public defender's name on the record again.
Dominic Cunningham for the Office of the Public Defender.
Okay, we have McVeigh, McKenna. I'm assuming if there's victims here, we'll see them. Public defender is appointed, battery on a person 65 years of age or older, battery domestic. No victims here that I can see. Anything from the state?
The state would request one of the conditions be no contact with either of the listed victims. As for history, there appears to just be, in the state of Florida, 1 prior misdemeanor, although it appears that there are active warrants out of Georgia, and that there is a failure to appear in that case, which appears to be a DUI. And that's it.
Okay, on count 1, there'll be a $2,000 bond. And a $100 bond on count 2 and $100 on count 3. No contact with the victims, separate residence. So no contact with either victim, separate residence.
Your Honor, we'd ask for a one-time return with law enforcement.
Yes, one time with law enforcement to pick up personal items. Okay, Ruben Montez. This is aggravated assault. It says he threw a stainless steel cup towards the victim's face.
And Your Honor, there is a victim present for this case.
Okay. All right, place her under oath, I guess.
Raise your right hand, please. You swear or affirm that the testimony you should give should be the truth, the whole truth, and nothing but the truth?
Yes.
All right, what is your name?
Laura Montez?
Okay, we're here today deciding what conditions of release to place on Mr. Montez. Do you have any input on that?
I would like for him to be released. I'm not scared of him. It was a misunderstanding. I'm not afraid of him, and I would love to have contact with him.
Have there been any prior offenses between you two?
No.
No? Okay, state?
Are you in fear of the defendant?
No, I'm not.
And would you like to have contact with the defendant while this case is pending?
Yes, ma'am.
And if anything were to happen, will you call 911?
If anything was to happen, yes, I would.
Say no further questions.
Does he qualify for pretrial release? Or?
Yes, Your Honor.
Okay, so we'll pretrial release him, order no hostile contact with the victim, he may return to the residence. Okay. All right, thank you, ma'am. Okay, Barreto. Lewis, violation of domestic injunction. Appoint the public defender. The victim here, okay, raise your right hand to be sworn.
You swear or affirm that the testimony you should give should be the truth, the whole truth, and nothing but the truth?
Yes,
All right, what is your name?
Loretto.
All right, again, we're here to decide what conditions of release for the defendant. What would you like to say?
I would like to keep him away from me permanently, as I am terrified of this man through many, many months of threats, which he tried to follow through on October 10th. I called 911. I went into another room, and he told me that I couldn't hide behind the law. And he also stated that the law will be too late when he gets mad. I stepped out of the home. I waited for the deputy. Lewis left the home. The deputy came. He made sure I left. This was October 10th. He made sure I left with some clothing, and I had some meds in my purse. I have no family down here other than an adult son and an adult daughter who lives with me, but she's immersed in her nursing career, so she's never home. And I didn't want to bring any of this to my adult son, who lives 3 hours away. He's a first responder, and he doesn't need any of these issues. I waited until Lewis was served, which was October 18th, and I know through my temporary injunction, he had 72 hours to turn in his weapons. Until then, I had not gone to my home to get any of my clothing, my meds, or to claim temporary possession of my home. I thought his weapons would have been turned over by then, so I called the sheriff, which I was instructed by the temporary injunction, to get a deputy sheriff to assist me to take over possession of my home, and Lewis shouldn't have been there at this time. When the sheriff, there were two sheriffs who met me at a corner, and they told me to follow them to my address, which we did, and his truck was in the driveway. They proceeded to go into the home, take him out because he had not left. They went into the home searching for weapons, and there were two big guns, two crossbows, and I did notice that he had always had a shotgun that he slept with underneath his mattress, and that was no longer there. So I don't know if he's turned over his guns and his weapons, but until then, I did not want to be in the home. Last night and yesterday, I was in the home as they took Lewis away, and I have to say, that was the first time I felt safe in my life. Because I had no one to turn to, I did go to Harbor House, and I felt secure now to follow through. But he will hunt me down, and he will kill me, and I know he'll probably take himself. But he has also threatened to bust my teeth, told me on a daily basis, as God is my witness, I deserve to have my teeth busted. He has more sympathy for a doe, if he were to hunt one. And the names, may I say, with no disrespect to the court, may I tell you what he calls me constantly, day after day after day? He calls me a mother effer, NIGCNT, every single day throughout the whole days. He had gotten in my face prior to October 10th. He had just gotten into my face and told me, he told me that he was going to make me so miserable that I will leave the home, and he's going to sell my home and cash in. And then October 10th, he took a very heavy insulated water cup. He was filled with rage. He stared me in the eye, and with full force, he threw that cup at me, and it was inches away from me. And had he connected that cup to me, I would have been severely injured in my head or my face. And that's when I called 911.
Okay,
Oh,
state
and
your,
excuse me, may I say something else?
go ahead.
I also babysit for my grandson, my
Hold on.
son, the first responder who lives
Hold
3
on,
hours away.
Hold
I
on.
babysit my grandson 3-4 days a week. It's
Judge Shoemaker. Hello? Yes. Okay, I'll get to it as soon as I can. All right, bye. More domestic cases. Okay, let me hear from the state. State?
Your Honor, given the testimony by the alleged victim here today, the state would ask that there be a bond with the PTR, even if he qualifies for direct PTR, and that there be conditions of no contact with the victim, no return to the scene, and to adhere to the injunction that is already in place in 2020 DR 12173.
Is there any other history?
It looks like there is no history, but the injunction was in place, it looks like October 12th of 2021.
Okay, well, the law requires me to set a bond, so I'm going to set bond at $2,500 plus pretrial release.
Your Honor, I'm not sure the conditions of the injunction, but if the injunction so allows, I would ask for a one-time return with law enforcement. Mr. Bretto did state that he does have belongings at that home.
Yes, he can return one time to the home only with a law enforcement officer, only to pick up personal items, no weapons, no firearms, no contact with the victim, no return to the scene other than the one time with law enforcement. He's not to possess any weapons or firearms. Yeah, of course, you have to comply with the injunction. On the injunction, it looks like it's 2021 DR 12173-0. So no contact at all, electronic, in person, you don't have anybody else contact her, no contact.
Yes, sir.
All right, thank you, ma'am.
Thank you.
Okay, Blackwell?
Yes, sir.
All right, this is a battery domestic violence. No victim here, what I see. Anything from the state?
Yes, Your Honor. In terms of history, there are 5 prior felonies, 9 prior misdemeanors, 6 prior failures to appear. There's also an active warrant for a violation of probation out of Tennessee. And that is all the information the state has.
Okay, I'll set bond at $5,000, no contact with the victim, separate residence.
Can I say? It says on there that there was no marks or nothing. I didn't do this.
Here you go.
Okay, then I'm gonna have to take a recess and go look at that emergency warrant, so I'll be back as soon as I'm done.
You're going to be placed in your attorney will call you. Make it right now. Formal charges. I am. formal charges against him, he would be set for an arraignment. I'm not sure that he has to make a filing. He doesn't, he doesn't take long.
All right, public defender's appointed. There's a warrant, violation of pretrial release condition on a domestic case. Warrant for violation of, actually violation of injunction. The bonds were set at 500 and 500. No contact with the victim or petitioner.
Yes, sir.
Okay,
Oh, you say my bond is 500, 500?
yes.
So what that is, 10,000?
It's 1,000. 1,000. Yes.
Guadalupe. Okay, public defender is appointed. It's a battery. We're going to order no contact with the victim. Anything from the state?
The state would just request no contact with the victim and to maintain separate residences. In terms of history, it looks like there were 4 prior arrests and 1 with this same victim, but no convictions.
Okay, so no contact with the victim, separate residence. No
Your Honor.
return to the scene except one time with law enforcement to pick up your personal items. And bond will be set at $2,000. Okay, we have Luis Neves, public defender is appointed. Says battery domestic violence. We have somebody here, I'll place him under oath.
Raise your right hand, please. You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, what is your name?
Victor Rodriguez.
Okay, what did you want to say about releasing the defendant today?
I want him released. I'm not scared of him. I want to remain with him. I want to have contact with him.
Okay, state, anything?
Are you in fear of the defendant?
No, ma'am.
No further questions.
Any history?
In terms of history, it looks like there are no known convictions. There is 1 prior arrest of a battery in Florida and an out-of-state arrest in Massachusetts. But that looks like it is just a traffic or malicious damage to a motor vehicle. And that's all the information the state has.
He
Your
does
Honor.
qualify for straight PTR.
What was that?
He does qualify for straight PTR.
Okay, we'll release you on straight pretrial release, no hostile or violent contact with a victim. Any questions?
No, no.
Okay.
Your Honor.
Yes. No fighting.
Next one is Welch.
Your Honor, she's medical.
Your Honor, at this time, we waive her appearance.
Okay, so we'll appoint the public defender. Waive her appearance. Or no contact with the victim, separate residence, no return except one time with law enforcement to pick up personal items. Any history or anything, state?
No, Your Honor.
Say there's mental health issues?
Your Honor, we were just told that it's medical, I'm not sure.
Oh, medical.
Your Honor, what was the bond set at?
I was just getting ready to set it.
Okay, sorry.
All right, we'll set bond at $1,500. Castaneda?
Yes, Your Honor.
There's 2 cases. Public defenders appointed. Okay, there's a possession of cocaine and paraphernalia. The bonds are 1,000 and 500. Looks like Division 14. And then there's a violation of probation out of county that's currently in no bond status, Seminole County. Public defender will help you on that until you're sent over to Seminole County. Cheney. Public defenders appointed. Okay, we have charges of sale and delivery of cocaine and fentanyl, possession of cocaine, possession of fentanyl. And he's out on bond on several cases, it looks like. 21 CF 5947, bond will be revoked. The RR will be revoked, go to no bond. Same with the 2021 CF 3849 AO. And the surety bond will be revoked on the 2021 CF 5912 AO. Those will go to no bond. New bonds will be stayed at 15,000, 150, 150, and 150. And then the driving while license suspended charge. That'll be a release on ROR. Yeah. Mhm. Dixon is next. Division 20, it says, false imprisonment, battery. Anything from the state? Bonds of 3,500.
I apologize, Your Honor, one moment.
There, of course, no contact with the victim.
Your Honor, I do believe he qualifies for pretrial release.
State?
In terms of conditions, the state would ask for no contact with the listed victim, no return to the scene, to maintain separate residences, and no weapons or firearms.
So no weapons or firearms, separate residence, no contact with the victim, no return to the scene. And you're good with pretrial release?
He qualifies for direct PTR, in light of no victim being present. The state has no objection to it.
Your Honor, if I may?
Mhm.
I've been informed that this is his home. The victim does not live there. If he returns with law enforcement and it's verified that she's not there, may he be able to return?
Does the state know anything about that?
Your Honor, it does appear, it says that this happened at his residence, or just to maintain separate residences.
Okay, so, yeah, strike the no return, just maintain a separate residence. No, we're doing pretrial release, right?
Straight free trial?
Yeah.
Okay.
Mhm.
Thank you.
Free trial.
Escalante Jr.,
Yes.
public defenders appointed. Okay, we have a arrest warrant here for battery domestic violence, so we're going to order no contact with the victim, no return to the residence.
Mm-mm. No. No.
You gonna keep the random urinalysis?
No.
Okay.
So your position on the battery bond?
The state, in terms of history, there is one prior felony conviction and 6 prior misdemeanors, several arrests in the state of Florida, including false imprisonment, and multiple VOPs in the history. So the state would leave it in your Honor's discretion in determining the amount.
All right, there'll be a $2,000 bond on the battery. Conditions, no contact, separate residence, no weapons.
Your Honor, may I have one moment?
No return. Yes. We have,
Thank you, Your Honor.
all right, then we have fleeing and eluding. And resisting without violence. Fleeing and eluding will have a $5,000 bond. The resisting will have an additional $150. All right, Ferguson. Sale and delivery of heroin, Division 17, public defenders appointed. Bond is at $15,000. Okay, Glover's next. Okay, there's a $500 bond on a failure to appear, Division 80. What else do we have? Fentanyl.
Your Honor, he's currently out on bond in case number 2020 CF 11477, and he's on ROR for case 2021 CF 4708.
So then we have an arrest warrant.
Yes, Your Honor, for the possession of fentanyl for 2021 CF 12685, there's a warrant. And it looks like they set the bond at $1,000.
Yes, so we'll stay that bond. And you're saying he's out on bond?
He's currently out on bond in the two cases, one for possession of fentanyl. He's on ROR 2021 CF 4708. And he's currently out on bond of a possession of a firearm by a convicted felon and resisting an officer without violence in case 2020 CF 11477.
Excuse me, Your Honor.
What, so what do you want me to do with the cases he's out on?
Well, for the 2020 CF 11477, the state would ask that his bond be revoked, and then,
So what offense did he commit? Said he bonded out on that on September 24th.
Your Honor, I apologize, you're correct. State would ask that there be no action taken on the cases he's out on bond for.
Okay,
I apologize.
all right.
You gotta.
Right. He really wasn't out on those cases. Okay, so he has a 500 on a failure to appear, and then the new warrant, he has a bond.
You're done. No action on your other cases? You have.
Anything else on his cases?
Nothing from the state.
There was no action on both cases?
There's what?
No action on both cases?
Right. All right, Hernandez. Public defenders appointed. Possession of Xanax, fentanyl, and cocaine. Says he's on surety bonds since August 16th. So those bonds are going to be revoked and go to no bond.
Your Honor, can I get those case numbers, please?
2020 CT 5017AO. It's a DUI. And our new bonds will be stated 1,000, 150, and 150. Okay, Houston, it's an aggravated stalking case, PD's appointed. No victim here, state, I take it?
No, Your Honor.
So what do you want as far as bond, state? The bond is set at $3,500 right now. No contact with a victim, obviously.
One moment, Your Honor. In terms of criminal history, there are 6 prior felony convictions, 4 prior misdemeanor convictions. The last conviction was for an aggravated battery in 2003. It was aggravated battery with a deadly weapon, attempted burg dwelling. Many prior arrests. In terms of conditions on bond, the state would ask that there be no contact with the listed victim, maintaining separate residences, no weapons, no firearms, and no drugs or alcohol, as that appears to be what started this.
Okay, so no drugs or, no illegal drugs or alcohol, no weapons or firearms, separate residence, no contact with the victim, no return to the residence except one time with law enforcement to pick up personal items.
Your Honor, I do not believe this occurred at an actual residence. I believe it was through a phone call.
That's true. So no contact, that means no phone calls, text messaging, emailing. Yes. Mhm.
Yes.
Pharaoh? He's what? Medical. We'll appoint the public defender. Do you want to?
Your Honor, we'd waive his appearance.
Okay.
What was the name?
Otero?
Oh, okay.
Possession of cocaine, resisting without violence, possession of drug paraphernalia, bonded 1,000, 100, and 100. Looks like Division 12. And we have Flores, as Flores. Possession of controlled substance. Paraphernalia bonded 1,000 and 100. PD's appointed. Perez Acosta. Public defenders appointed. And it's aggravated assault with a firearm, burglary of a conveyance, and assault or battery, possession of prescription without a, possession of a prescription drug without the prescription. Burglary of a conveyance has no bond. Aggravated assault with a firearm. Stay at no bond. $500 on the drug charge. No contact with the victim. PD appointed.
Counts 1 and 2 to stay at no bond,
Mhm.
and then 500.
Yep. Adam Phillips. Looks like Division 17, arrest warrant here. Possession of a firearm by a convicted felon, possession of ammunition by a convicted felon. Possession of a firearm by a convicted delinquent. Ammunition by a convicted delinquent. Grand theft firearm, reckless display of a firearm, negligent storage of a firearm, neglect of a child, unlawful possession of a stolen credit card. Bonds are 25,000, 1,000, 150, 150, 1,000, 2,500, 150, 150, and 150. Yes, he's not to possess any weapons, firearms.
Your Honor, the state would request no contact with any victims as there's a neglect of a child.
No contact with any of the victims.
There was a warrant.
Ramos. Public defender appointed. Possession of fentanyl. Bond's $1,000. And he's out on bond. On 2021 CF 1025. All right, that bond will be revoked, go to no bond at this time. The new one's 1,000.
Good to go.
Reyes. All right, there's trafficking in fentanyl, trafficking in oxycodone, possession of a controlled substance with intent to sell. And then you're out on bond, 2021 MM 4494AO. And that bond will be revoked and go to no bond. Driving while license suspended charge, that bond will be stayed at $500. And then your trafficking in fentanyl has a bond of $1 million. Same with the trafficking in oxycodone, $15,000 on the controlled substance with intent to sell. So Division 17.
Your Honor, the state would ask that there be no, as a condition of the bond on the cases, there be no drugs without a valid prescription.
All right, well, we're in possession of no drugs without a valid prescription.
Your Honor, if I may be heard,
Go ahead.
the defense would just ask that the court consider lowering the $1 million bond amount to a bond in which the defendant would be able to afford.
State?
Your Honor, in terms of criminal history, there's one prior felony, 2 prior misdemeanors. However, notably, she did displead to a DUI in August 18th of 2021, so this will probably violate her probation in that case. Additionally, it looks like there are 2 prior failures to appear, and that there is an open case that she's out on bond for. In light of that, the state would leave it in Your Honor's discretion. Just would like the court to take that into consideration.
I'll stay the bonds at this point. Okay, John Sakish. 2 charges. You got possession of heroin, bond set at $1,000. Down delivery, the bond is set at $15,000.
The state would just ask as a condition of the bond that there be no drugs without a valid prescription.
Right. Do not possess any illegal drugs.
In both cases.
Yes. James Taylor.
You're done, Taylor.
Okay, there's an arrest warrant. grand theft alleged on September 28th of 2021. And, he's out on bond, it looks like. 2021 CF 12352AO. So that bond will be revoked and go to no bond. And then, let's see. The new warrant has a $12,000 bond, is that correct? Yes, grand theft. No contact with victims. Let's see. No return to the scene, no return to any storage units anywhere, per Judge Beckman, maybe? Okay. Warner? Okay, petty theft, 2 prior convictions. Looks like there's a warrant. Capia set at $1,500. Is that all he has? Thick packet of paperwork here for that. Right. Probable cause order, so says do not return to the scene of the offense. No contact with victims. Okay. Your DUI ticket? The charging affidavit, which is the ticket, so, to Jimenez.
Your Honor.
There's a citation here for driving under the influence. Bond set at $1,000. Is that the only charge? Yes. Are public defenders appointed?
They would ask that a condition of bond be no drugs or alcohol, given the charge.
Do you have prior history, or?
It looks like there's no prior history of convictions, but there is a prior arrest for possessions of cannabis and drug paraphernalia.
All right. I'm not going to put any other conditions on it.
Just the bond.
Just the bond.
Just the bond.
Silva? Driving under the influence, bond is set at $500. Public defenders appointed.
Your Honor, if I may? I do believe he qualifies for pretrial release.
Is he qualified?
Yes, Your Honor.
Anything from the state?
State has no objection if he qualifies.
Okay, pretrial release.
Any conditions, Your Honor?
What's that?
Any conditions?
No. Pretrial release. Jeremiah Davis. Charge of trespass on property, bond is $500.
Your Honor,
Yes.
the defense would ask if the state had an offer for this case.
Oh, there is no offer.
So $500, no return to the Lynx bus station, Garland Avenue. Willie Flores?
Yes, sir.
Your Honor, may I be heard on Mr. Flores?
God bless you, Your Honor.
Okay, it's a disorderly conduct bond of $250. What would you like to say?
Your Honor, there's no probable cause for disorderly conduct. We ask for ROR at this time.
There's no probable cause, okay. Let's see. This is a violation of the city ordinance, 4306, disorderly conduct.
Your Honor, I do believe that this is possibly panhandling, but there's no, within the four corners, I do not believe there's PC for disorderly conduct.
Does anybody have a copy of the ordinance?
Statute.
Doesn't seem to be a violation of the state statute for disorderly conduct, but I don't know about the county or the city ordinance. I'm going to RR him anyway. See. Assume the city attorney's not here.
Brenna Jones for the state, Your Honor. I also agreed that I didn't think that there was PC, even if everything in the affidavit were true. I don't think that this would rise to the level of a disorderly conduct as panhandling. I don't think is probable cause.
I'll just ROR him, find a lack of probable cause, and the city can charge it if they wish to.
Thank you, Your Honor.
Doesn't look like a typical disorderly. You want to be appointed on that one? We just did?
Yes, Your Honor.
Yes, okay. All right, come on up, what's your name? Public defenders appointed, this is a resisting without violence, possession of cannabis, bonds of 500 and 100. Is that on bond, it says?
Your Honor,
Yes?
at this time, we'd be asking for an RO on the possession of cannabis. It's my understanding that the state attorney's office is not prosecuting possession of cannabis less than 20 grams.
Okay,
That's true.
okay. So RR on the possession of cannabis, 500 on the resisting, but then he's out on bond. On the 2021 CF 13674AO, bond to be revoked, and go to no bond. No, no 100, just a 500 in RR. Mhm. No, just RR. Okay. All right, what is your name?
What's your name?
Jamie Turby David.
Put your hand.
Turby David, okay. Public defenders appointed, you have a new charge of possession of paraphernalia, bond of $500. He's out on 2021 CF 13316AO. Revoke that bond or go to no bond? Calderon Rivera's next.
Yes, Your Honor.
These are out-of-county warrants, set at 3,000, 2,000, 1,000, and then it says 3,000/RR. Or plus ROR, 3,000 plus ROR.
All count.
No, it's 3,000 on one, we're going to stay it, or it says all counts?
It's third page. My boss said two, but, after each one, it says plus. It's crazy.
Okay, so each count has a bond and R, and,
You had to say plus. I don't know. Yeah, it was weird.
Plus?
I just put it how they, because it doesn't make sense. It should be for. It says plus, so I had to. And for GPS monitoring on all counts. Yeah, so.
so I have to go back to Manatee County eventually. I'm just going to stay the bonds as they put them in the system.
Excuse me, Josh, I think I finished this case. I don't know what is still open.
All right, we're appointing a public defender for right now. Pope. You have warrants out of Polk County.
Yes, sir.
Bonds set at 1,000, 5,000, and 1,000. And let's see. Okay, then your other case is, okay. Three more. Four, looks like out-of-county warrants, again, out of Polk County, bonds at 1,000, 500, 500, and 1,000. So we'll stay whatever they,
The one correction on that one, on count 3, it's 5,000.
5,000 out of,
Not
out of 500. Okay. Yes, it is 5,000. Okay. Public defender will be temporarily appointed while you're here. Soto, out-of-county warrant, there's no bond.
I just was wondering, do you know why I'm here? If my public defender was supposed to remove my warrant since I have a court date on Wednesday?
We'll appoint the public defender to help you while you're here. Okay, next one is Brown. Public defender is appointed. Probation violation, there's currently no bond, Division 19. ED's appointed. Next one's Diener. All right, there's a failure to appear, there's no bond. Appoint the public defender. Division 16. Oh, he has another one, it looks like. Division. And sir, you have another one in Division 20, a violation of drug probation. There's no bond as well. Public defender will be appointed. Okay. Hodge.
Sir.
Violation of probation, there's no bond, Division 15, public defender will be appointed. Okay, Manning, violation of community control, Division 16, public defender appointed, there's no bond.
Okay, you have to tell.
Knopfsinger's, Division 19, violation of probation, there's no bond. Cabrera. Division 84 is a disorderly conduct. says bond of $250. Will appoint the public defender, your bond's $250. Parker,
Sir.
disorderly conduct, bond's $250.
So I just have one thing to say. My name actually is Packer, not Parker.
Okay. Hello. Okay. Okay, is that the one from earlier? Yeah, I'm just finishing up in court here. I couldn't get it to open here in the courthouse. Did they say why it was a emergency? Okay, I'll look at it. Probably another 20 minutes. Okay. Bye. Okay, I'll release you. Is he qualified for ROR or?
Well, he wasn't interviewed for PTR.
This is what'd you say your name was again?
Benjamin Packer.
Packard. All right. It's marked as Parker.
Your Honor,
Yes?
because he was not interviewed, we'd ask for him to be interviewed for pretrial release, and if he does qualify to be released on pretrial.
I was probably just going to ROR him, actually. It's just a,
ROR works too.
and he's not to return to the, is it called Club Shots? Is that what it's called, Club Shots? No return there?
Yes, sir.
Wait for the state to do something?
This is all the paper I have.
Or we can you put AKA? Okay.
Judge, I have the victim on the phone. She's appearing telephonically.
How are you this morning, Your Honor?
Hello.
Hello.
Okay, we need to get, everybody that's speaking, we need to get their names on the record.
Good morning, Your Honor. Belkacey Izquierdo from the Public Defender's Office. I did speak to Mr. LeBron. Mr. LeBron does not want to be represented by the Public Defender's Office, but I am appearing as a friend of the court.
Jennifer Dunkirk, pretrial release.
We'll see. Okay, so this is a charge of battery. And Mr. LeBron, you want the public defender to help you this morning?
There's a severe conflict of interest due to the way the public defender gets paid and the state attorney gets paid. It's never worked out too well for me in the past. I would just ask if I may assert my rights during the proceeding at some point, whenever you're ready, so I can make my legal argument. Thank you so much, Your Honor.
Okay, so how much education do you have?
I'm self-taught. I've taken my education to the highest degree possible by reading books over the last 15 years.
Do you have any legal training?
Do I have any legal, what?
Training?
I'm a Black's Law's lawyer, which makes me an attorney in fact, and I'm actually the administrator over Daniel LeBron in this matter. I'm not the person. Thank you.
I need Daniel LeBron. Is that you or not?
I'm not a person. I'm the administrator. Just like you're the administrator of this court, you're not the court. So that's the capacity I'm operating in.
Yeah.
I just would like to say something since we're at this juncture. I think that jurisdiction is important and according to the law can be brought up at any time. I would like this court to present their jurisdiction by providing a dictionary.
No, sir, you're incorrect on that law,
Please,
sir.
thank you. Can you please provide me
Okay,
that
so there's a
document, Your Honor?
probable cause for the battery charge. You said the victim's online, state, or public defender, or somebody said the victim's here, is that correct?
Stop shutting my mic off, please.
Your Honor.
Why are they shutting my mic off?
Because he's talking. Your Honor.
That's
Miss-
not allowed to
Miss-
shut my
the-
mic
the
off. That's-
agent- Record.
Judge, I have got
Yes.
I have got the victim appearing telephonically, and she would like to speak.
Okay. Are you there, ma'am?
Ms. Perlman?
Yeah, I'm on a phone call. Yes, I'm here.
Ms. Perlman, you're on the record,
Okay.
and you're the victim of Daniel LeBron. Is there anything you'd like to say to the judge?
Yes, I would like to say that the allegations against Mr. LeBron
Your Honor, I
are fake.
apologize for interrupting.
They are not true, and
However,
I do wish.
give me 1 second.
I do wish to
Miss,
have.
please do
I'm
not
sorry, I
continue
don't know if
speaking.
someone's talking.
Perlman.
I do.
Your Honor, I apologize for interrupting, but at this time, I'm going to object and state that I'm
I'm not with the public defender's office. The public defender's office doesn't represent me.
to not speak about the facts of the case and
The
only
public
whether
defender's
she
office
is in fear or not of
Doesn't
Mr.
represent
LeBron.
me.
That is all.
Excuse me, I would like you to remove this friend of the court away from my case because she's interfering and she's damaging and injuring me in a way that in an irreprehensible way where I can't go backwards. So can she please be removed from the podium? Because she doesn't represent me. And
Yes, she's not your attorney at this point. I have found probable cause in this case.
Well,
I'm going
notice that the summons was
to
already issued.
set bond at $1,000, and you're to have no contact with the victim and separate residence.
Well, can I say one thing about the probable cause? This is the last thing that I'll say.
Go ahead.
If we're going to look at the probable cause, we need to look at the evidence code according to the Florida Evidence Code and the Criminal Rules of Procedure. And in the evidence code, it specifically states that hearsay is not admissible as evidence. And all I see in this complaint is hearsay. People saying
Well,
something
sir,
to one
so
person and then
that's where
swearing
your
in
legal
and telling the
training
court.
is very, very wrong. That's all we have
I know,
in
but
these
it's-
hearings is hearsay.
Yeah, but the thing is,
Everything's hearsay.
is
It is
not allowed-
admissible.
Your Honor, if I just may finish my thought, I do respect you completely.
Bond set at $1,000, no contact with the victim,
Evidence
separate
codes-
residence.
The evidence
Next
code
case.
says that you can't submit hearsay as.
Bowser is next.
No
Nope.
appointments.
What's that?
No PD, right?
Nope.
Your Honor, regarding Mr. LeBron, may he be allowed a one-time return to the property with law enforcement to obtain his belongings?
Well, you don't represent him. He didn't want you, so until that's properly brought before the court.
Thank you, Your Honor.
My apologies. As an officer of the court, I still have the victim on the line. She's requesting to have contact with him and to return home. They were here on vacation. When he was arrested, he has the keys to the vehicle. She has no way to get home, and she has two small children, and this is why she could not appear today. This is why I'm trying to assist as an officer of the court to have her appear telephonically.
So where are the keys at?
In property with Mr. LeBron.
Well, I'll authorize you to turn the keys over to her.
She has no way to get them.
I can't get there, and the police wouldn't give them to me when they arrested him. The police were very nasty to me.
Well, I don't know what else to tell you.
The police officers that arrested him said I could not get the keys. They said they know the case will get thrown out in court, but they're taking him to jail anyway.
Ms. Perlman, are you requesting a non-hostile contact?
I am.
No, I've already ruled, so we're moving on to the next case.
Thank you, Judge.
Thank you, Your Honor.
Yes. Yes, you can pick up the keys. Just need to figure out how to do it. That's no contact with him, though.
So pick up the keys from property at,
Mm-hmm. Okay. So we have Bowser next.
Mr. Bowser? Yes, Mr. Bowser is present and approaching, Your Honor.
So again, we're appointing the public defender unless otherwise stated. This is a failure to appear, a bond of $2,500.
You gonna tell them we want to take care of this?
Yes,
today?
PD's appointed on all of them.
Ma'am, we're gonna tell them we want to take care of this today?
Your Honor, Mr. Bowser would like to ask the court if there's an offer on this case.
An offer? I don't even know what the charge is.
Driving while license is revoked, sir. Second offense. I have 180 days in Pinellas County Jail before I came here. And was arraigned in Pinellas County.
Does the state have anything on this?
Yes, Your Honor, I looked in our case management system, and it looks like that the capias started in March 11th, 2021, but prior to that, in the notes, the offer was adjudication of guilt, credit time served, and court costs.
That'd be fine. Thank you, State.
Is the public defender there with him?
Yes, Your Honor. Balkis Izquierdo, on behalf of the Public Defender's Office, I did inform Mr. Bowser that I do not have additional information on his case, that although I believe it might be in his best interest to wait to speak to an assigned public defender, he indicated he wanted to plea this out.
Yes, I want to get this behind me and over with.
This might habitualize you. I don't know. This can cause a lot of other problems for you.
And Your Honor, again, as I stated earlier, I don't even have a driving record. I did explain that if he pleads this out, this could habitualize him.
It's all right.
Do we have a factual basis for the plea?
I can bring one up.
Thank you, Judge.
On November 26, 2020 at 2056 hours, Sergeant Souza observed a black Dodge that was a suspect vehicle in a residential burglary in the area of Florida Avenue and 4th Street in Osceola County, Florida. The tag of the vehicle matched that of the suspect vehicle. There was a traffic stop that was initiated. The driver was identified as the defendant, and a check of the license indicated that he had 9 suspensions for failure to pay a traffic fine. He advised that his license has been revoked since 2018.
We don't know what his other driving history is.
This will habitualize him. I have a copy of the driving record in the discovery packet. It looks.
Do we know how much credit time served he has?
It looks like he had 27 per the notes, but that was back in February. I don't know if he was in Pinellas. I'm not sure if he was arrested on something else and not this. I don't know if he would be entitled to that credit.
All right, so State, do you want to take this plea today or not? What do you want to do?
If the court is willing, the state would do the plea.
And you're offering adjudication, time served, and costs?
Yes, Your Honor.
All right. Is he under oath? Raise your right hand, sir.
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
What is your name?
Jonathan Michael Bowser.
And do you have the charging documents, State? Do we even know what he's charged with? Is it?
He is charged with driving while licensed, suspended, subsequent offender.
Okay.
Florida statute 322.34 sub 2 sub B.
All right. So you're charged with driving while licensed, suspended with knowledge, a subsequent offense.
Yes, sir.
According to the state, if you plead guilty or no contest, you're going to be habitualized and lose your driving privilege for 5 years. Are you aware of that?
Yes, sir, I understand that.
You need more time to talk to your attorney about that?
No, sir, I'm willing to go on and take care of this today.
Anybody forcing you to plead today?
No, sir.
Is there a plea form down there?
Yes, Your Honor, I have the plea form before me. Also state through what year would he be habitualized? So he'll be habitualized until 2026?
Well, it's up to DMV.
Yeah.
Whenever they start it.
Your Honor, I gave Mr. Bowser the plea form. He is currently signing it.
Yeah.
Then how much are the court costs there? I don't know if I have the authority to take a plea. I'll see.
It's going right.
Yeah, State, I'm not sure I have the authority to take a plea in Osceola County. I know under the COVID restrictions we could. I just don't know.
Oh, that might be true.
Yeah. Okay. All right. I don't think I have the authority to take an Osceola County plea at this point. I know back under the COVID restrictions we did, but I don't think that's still out. So I'm not going to take a plea.
You're just gonna state a bond? Appoint the PD.
Yeah, public defender's appointed. Bond's at $2,500. Next one is Mark Brown. All right, what is your name?
Your Honor, I apologize. I was on mute. I indicated that Mr. Brown was present and approaching. Due to the nature of the charges, I would be requesting a waiver of formal reading. Mr. Brown is aware and consented. He is present.
Okay, so we have a battery and a false imprisonment. Is there a victim present, State, or anybody?
I don't have any information if the victims have appeared in Osceola.
They would actually be over in Orange physically.
Your Honor, there's no victims. We don't have any Osceola victims.
Okay.
We were unable to contact the victim. We did leave a message, Judge.
Okay, so I will set bond on the battery at $1,000, no contact with the victim, no return to the scene, and a $2,000 bond on the false imprisonment, same conditions.
You found a PC, right?
Yes. I've made PC findings in all cases, unless I state otherwise.
And Your Honor, regarding this case, may Mr. Brown be allowed a one-time return to obtain his belongings with police escort?
Yes, only with law enforcement. He can return one time to pick up his personal items.
Thank you, Your Honor.
Forget to scan that thing. Silly. We have Brutus.
Your Honor, Mr. Brutus is present and approaching.
It's possession of drug paraphernalia, a controlled substance without a prescription. There are 2 cases. Okay, and bonds were $500, $1,000.
Judge, just to be
Um,
clear, on the possession, it's 500, and on the possession of drug paraphernalia, 500, and on the controlled substance, $1,000?
That's correct. That's what's,
Thank you, Your Honor.
yes.
Judge, Mr. Brutus actually qualifies for a direct pretrial release on both cases. Would court be able to entertain that?
What's the state's position on that?
The state would leave it in Your Honor's discretion if he qualifies for direct PTR. State has no objection.
He qualifies?
Yes, Judge.
This is Bruce. Okay, based on the state's agreement, we'll place him on pretrial release.
On both cases,
Yes.
Judge?
Yes.
Any conditions, Judge?
Yes, he's not to possess any illegal drugs or controlled substances without a prescription.
Thank you, Judge.
Thank you, Your Honor.
Yes.
Your Honor, Mr. Concho Gonzalez, I believe, is the next person you would call. However, he requires a Spanish interpreter.
Okay.
Do you want to do him now, or you want to wait and call him again?
Are there more interpreter cases?
Ask them if they.
And Your Honor, this is the only interpreter case that we have for this morning.
Okay, so I need to call the interpreter?
Yes, Your Honor.
I have to add a phone?
Add a call. Listen.
Add?
Yeah. And then it should say. Or the, yeah.
Hello, Cisco Unity Connection Messaging System. From a touch-tone telephone, you may dial an extension at any time. For a directory of extensions, press 4.
Trying to get Osceola back up.
Osceola, can you hear the interpreter?
Yes.
Okay.
I don't know why the screen is blank.
All right. So this is Concha Gonzalez.
Yes, Your Honor.
Señor González?
Sí, buenos días.
Yes, good morning.
Okay, so the public defender is appointed. This is,
Swear the interpreter was.
okay, the interpreter, are you sworn in yet?
Not yet, Your Honor.
Okay.
Raise your right hand, please. Do you swear to translate from Spanish to English, English to Spanish truthfully in these matters here today?
Yes, I do. Dalia Romero, State Certified Spanish Interpreter for the record.
Osceola County, can you turn your video on?
We could see you, Judge. Well, Orange County.
I gotta turn off video.
I lost, okay. I
Okay.
have you back on the screen, Your Honor.
Okay, well, so this is battery on a pregnant person.
Este es un caso de agresión contra una persona, una mujer embarazada.
Is there a victim present or online?
No,
¿Tenemos una víctima presente o en la línea?
no, Judge. We spoke to the victim.
No, su señoría, hablamos con la víctima.
And the victim does not want to have any contact.
Y la víctima no quiere tener ningún tipo de contacto.
For the court's record, he has no criminal history.
Y para el expediente de la corte, él no tiene antecedentes penales.
Okay, so I'm gonna order no contact with the victim. Can you make $1,000 bond?
Bien, voy a ordenarle a que no tenga contacto con la víctima. ¿Usted puede pagar una fianza de $1,000?
Le están preguntando.
Si puede pagar una fianza de $1,000.
Eso es lo menos.
¿Perdón?
Eso es lo menos.
That's the least?
O sea, no sé, sí.
Diga si puede pagar $1,000 o no.
Sí, sí.
Yes, yes.
Okay, so $1,000 bond, no contact with the victim. Anything else from either side?
Bien, la fianza son $1,000, no puede tener contacto con la víctima. ¿Alguna otra cosa de alguna de las dos partes? Pregunta el juez.
Your Honor, Belkis Izquierdo from the Public Defender's Office. I would just like Mr. Gonzalez to have the ability to return with a one-time law enforcement escort to retrieve his belongings.
Su señoría, la abogada de defensor público, la señora Izquierdo, está pidiendo que se le permita al señor González regresar a la propiedad en una sola ocasión, acompañado de la policía, para poder retirar sus artículos personales.
Well, this happened basically at a car at a parking lot. So I think these things may be in the car, so I have no objection to him.
Esto aparentemente ocurrió en un estacionamiento y a lo mejor sus pertenencias ya estaban en el carro. El juez no tiene ningún problema que se le permita regresar, pero acompañado de la policía, solamente una vez.
Yes, Your Honor, and I apologize for misspeaking. I meant a one-time return, I guess, to the vehicle to obtain his belongings from there.
Yes, you can do that one time with law enforcement.
Thank you.
Es al vehículo, una sola ocasión, a retirar sus artículos personales, acompañado de la policía.
No, en la casa. En el apartamento.
¿Cómo?
Es en el apartamento, no en el carro.
Pero el incidente ocurrió en un vehículo, ¿no?
Sí, pero tenía solo un bolso. Las cosas están en la casa.
Diga eso.
En el vehículo solo hay un bolso. Yo iba de regreso a la casa a buscar mis cosas.
In the vehicle, I only had one bag, but I was going back to the apartment, to the house, to pick up my belongings.
All the PD's name. All right. So we need the state and the public defender to state and spell their names.
Brenna Jones, BRENNA JONES for the state.
Belkis Izquierdo, BELKYS, last name YZQUIERDO for the public defender.
Tenemos a la señora Jones y a la señora Izquierdo. Aquí, la señora Izquierdo de la Oficina de Defensores Públicos y Jones, la fiscal.
All right, so the next one we have is Fisher, is that correct?
El próximo que tenemos es... Oh,
Yes, Your Honor, Mr.
was that the only Spanish? Was that the only Spanish, Your Honor?
I believe so, yes.
Yes.
Would you like for me to make an announcement, or we're good?
Public defender, are you sure that's the only one?
Yes, Your Honor.
Okay, thank you.
Thank you. Thank you, Your Honor.
Now we got him back. Since we got rid of the interpreter. So Fisher's here on an out-of-county warrant. Will appoint the public defender. There's currently no bond. All cases.
Yeah.
That's otherwise. Garner?
Thank you. Fisher, you can have a seat. Mr. Garner? Mr. Garner is present and approaching, Your Honor.
And Mr. Garner has a trespassing on property. The bond set at $250, or is this a pleable? I can't take a plea down there. I keep forgetting. Okay. The bond's $250. He's not to return to the area where this happened.
Judge, for the record, Mr. Garner does qualify for a direct pretrial release. Would your court be able to entertain that?
State?
The state doesn't object to a direct PTR, but would request there to be a no return to the scene as a condition of his PTR.
All right, so it's direct pretrial release with no return.
Thank you, Your Honor.
Okay, and that's the Lynx bus stop, number 951. Hoyle?
Mr. Hoyle is present and approaching.
Okay, public defender is appointed. This is a arrest warrant, looks like on a violation of probation. There's no bond. Next one's Langdale.
Have a seat. Ms. Langdale is present and approaching, Your Honor.
Okay, this is a petty theft charge, and the defendant was out on bond, it appears.
Yes, Judge.
So the bond's going to be revoked on the cases. The defendant was out on bond. Go to no bond.
And Your
This
Honor,
petty theft will stay at $500, no return to Walmart.
For the record, that case number that she's out on bond, Judge, is case number 2021 CF002137.
Correct.
and Your Honor is finding PC for the petty theft, correct?
Yes.
Thank you.
Lena Natali.
Mr. Natali is present and approaching.
Okay. Looks like he has a failure to appear. Judge set bond at $12,000. Next one's Robert Wall.
Mr. Wall is present and approaching.
Judge, we have had no contact with the victim, although Mr. Wall does qualify for bond with pretrial release.
Okay, so at this point, I'll order no contact with the victim, separate residence. They can return one time to pick up any personal items with law enforcement. And state your position on bond.
The state would request that there be a bond set with PTR if the court is inclined to do that.
All right, $1,000 bond plus pretrial release.
Thank you, Your Honor.
Hmm?
Oh, Your Honor, regarding probable cause, has Your Honor found probable cause?
Yes, it wasn't a whole lot there, but I think there's enough. He says she tripped. He said he pushed her. I think we'll know where that case will end up, but. Okay, Avery?
Thank you, Your Honor. Ms. Avery?
Okay, public defender is appointed. This is a grand theft warrant. Bond was set at $1,000.
It's actually not at, the car is still at Publix. He was already found, or you found it?
Your Honor, may I be heard on Ms. Avery's case?
Yeah, is this a warrant or is this a new?
This is
I don't have any facts. I thought this was a warrant.
This is a warrant.
Is it?
Yeah, Brennan Jones for the state. It is a warrant. Case 21 CF 3078. The warrant was signed by Judge Blackman.
Okay. So probable cause was established by Judge Blackman.
Your Honor, may I be heard?
Sure, go ahead.
According to the police report in case number 21 CF 3078, the warrant, although confirmed and later served, the warrant was canceled via an email sent to the SO Judicial, according to the police report.
You know, I canceled a warrant the other day. I don't know if it was this one. It might have been.
Defense would just like confirmation on whether the warrant is in fact canceled or it's active.
Anybody know?
Is it relevant, or it should be canceled because the police officer was supposed to return the car?
Was supposed to return what?
The car, I was arrested, so the car was supposed to be returned. It wasn't stolen. So it shouldn't be any charge.
Does the state have any idea about the warrant?
Your Honor, I have no information as to whether it was canceled. It says here that the warrant was issued on the October 21st, 2021. I have no information that the warrant's been canceled.
Your Honor, may I be heard?
Yes.
I'm referring to the police report that we all received for initial appearance this morning. It clearly states the warrant was canceled via email. It's the last sentence of the police
Yeah,
report.
they canceled.
And the date of this police report is October 22nd.
The warrant was canceled via email. So
In light of there being, I see what council's talking about. In light of there being no active warrant, for case number 2021 CF 3078, I also can't find that case exists. This state would just request that she be released.
Okay.
just ROR at this point?
Yes, Your Honor.
Okay. Just enter an ROR. You know,
You're welcome.
stay in touch with the public defender to make sure it was dismissed, if it was.
I will, thank you.
So no PC, Judge?
Well, that was a warrant.
Thank you.
You're welcome.
Okay. Okay, we have Berkeley.
Your Honor, Mr. Berkeley was not feeling well at this time. I'm asking for him to be reset for tomorrow. Mr. Berkeley is currently in detox.
Okay, well, your office is appointed.
Your Honor,
You can waive his appearance and we can just set the bonds.
I would ask for a one-time reset, Your Honor. I will be the public defender appearing tomorrow.
Okay, reset.
Thank you.
We have Carbella Ruiz.
Yes, Your Honor, she's present and approaching.
This is an active warrant. It's a $10,000 bond. Public defender's appointed.
And Your Honor, Ms. Caraballo Ruiz wanted me to inform the court that she believes the public defender from Orange County submitted information to the court regarding Ms. Caraballo Ruiz being allowed to resolve this case today, and I'm not sure if Your Honor has that information.
No.
Ms. Ruiz indicated she does want to resolve this case. I'm not sure if Your Honor would be able to accept the plea this morning.
All right, state.
Your Honor, the state doesn't have an offer on this case. I will note that there's been several capiases, so I'm not really inclined to make an offer without more information.
Excellent.
Has she hired a private attorney on this case?
Looks like she's represented by RCC.
Oh, that's the RCC counsel, David. Okay, we're just going to stay everything at the $10,000 bond.
And Your Honor, I apologize for misspeaking regarding our representation of her in the Orange County case.
Right, we're staying everything. We have Smith, Gregory.
Mr. Smith is present and approaching, and Your Honor, regarding the nature of the charges, I would be asking for a waiver of the reading and for the charges to be referred to as count 1 or count 2.
Your Honor.
Okay, what's the state's position on bond?
One moment, Your Honor, I'm looking up the history.
Judge, I have the history, if the court would, wants me to provide that.
Yes, please.
Mr. Smith has no Florida priors. He has a history out in New Jersey, aggravated assault, robbery. He was sentenced to prison for that. He is also in custody on several charges, similar to what he's here for today, 3 to be exact. I believe the bond is undetermined. His last conviction was 2004.
All right. And as charged, this is a second-degree felony?
I believe, yes, Your Honor. He's entitled to bond. However, the state would request that in light of the facts and circumstances contained within the 4 corners of the arrest affidavit, that the bond be set at an appropriate amount given the facts, and also that there be no contact with the listed victim and no return to the scene of the arrest.
Yes, we will order no contact with the victim. No return to the scene. And I'm going to set bond at $20,000.
And did Your Honor find PC?
Yes.
Thank you.